So now we're moving into the Idahofour Moscow murders motion in limine rulings from the judge that were posted yesterday. So they're fairly new. I just did a summary of all the ones that he stated in a document that was also posted yesterday, but were actually ruled upon in the hearing on April 9th, and he was just summarizing all of them. Now we're getting into the new ones. So this is regarding the make and model of the car. The state stitched together a bunch of videos that they found with surveillance around Moscow to try to provide a path of travel that they believe is the suspect vehicle number one. The defendant is alleging that because it's not one continuous video that these could be different vehicles, and they're just alleging that it's the same. It also was given a length of 2011 to 2016, and Brian's car is a 2015, and they're saying you shouldn't be able to alter that after the fact and try to pin it on him. So Brian is trying to argue that it's not relevant and unfairly prejudicial and invades the province of the jury. The state responds that the testimony is based on logical, educated inferences drawn by law enforcement from the surveillance videos. And the defendant is attempting to prohibit the state from arguing and asserting that the fact that the vehicles are the same or that suspect vehicle 1 is a 2014 to 2016 Hyundai Elantra. And he says he is correct that it would be speculative and improper without expert testimony to provide a basis to make this contention. However, this prescription does not prevent the state from eliciting such opinions from law enforcement and asserting this is an allegation during the trial based on the testimony. The judge goes on to say that the opinion is based on the investigators' training and experience and educated inferences drawn from their review of surveillance footage from 6 locations within the mile of the crime scene during the hour preceding the crime. From this evidence, the investigators were able to map what they believed was the suspect vehicle's route of travel preceding the crime, as well as identify its make and model, which they did poorly because they said one thing and then said a different thing later after they knew who Brian was. The judge basically says that the fact finders are the jury and they are to determine if he is the one driving this vehicle and if this is his path of travel, if it's the same vehicle. So because of that, his motion for the make and model and this footage to be not shown is denied. So now we're moving into the testimony for Riley Nowlin, who was the lab manager at the Idaho State Police Forensic Lab and who was disclosed by the state to testify about touch DNA and the transfer of DNA generally, and more specifically the DNA located on the knife sheath was more likely the result of a direct transfer. Defendant argues that Ms. Nowlin's testimony, as well as any other testimony referencing the terms touch or contact DNA and or purporting to be an opinion about the means or mechanism how the DNA ended up on the knife sheath, is irrelevant or impermissible under IRE 403 and fails to satisfy our IRE 703. So it says a knife sheath was recovered from the crime scene in this matter and swabbed for DNA. A sample of DNA identified as Q1.1 was extracted from the swab by the ISP forensic lab. The DNA concentration was 0.168 mg/UL. It was subsequently tested using the standard DNA STR or short tandem repeat methods. The STR profile developed revealed that the DNA came from a single source male profile. The state disclosed Riley Nowlin, the lab manager of the ISP lab, to testify to the operations of the forensic laboratory, the structure of the ISP lab, and the types of evidence it processes. Her disclosure further states, Ms. Nowlin will also testify to touch DNA and transfer DNA. So Ms. Nowlin apparently gave 2 different disclosures. She did one where she talked about what touch DNA and transfer DNA is, and how Nowlin will testify to the characteristics and nature of touch DNA, including how it is deposited, transferred to an item of evidence, etc. Then she also did another disclosure where she talked about the other factors that could influence the transfer and persistence of DNA on an item. So he was quoting her disclosures, and then he said that the defendant's argument is threefold, and so he's going to address them individually. So with the issue of Ms. Nowlin being able to offer disclosed testimony about DNA transfer, the first issue is Ms. Nowlin is she sufficiently qualified to do so? They're saying the defense is saying Ms. Nowlin is not qualified to render an opinion on DNA transfer, that the defendant contends within the forensic community, there is a consensus that only experts specifically trained in DNA transfer are qualified to render such an opinion. To establish the consensus that they're talking about, they reference 2 forensic science publications regarding DNA transfer. So the court declines to find that Ms. Nowlin lacks the qualifications necessary to provide an opinion on DNA transfer. In this case, defendant's challenges to her qualifications affect simply the weight to be afforded her testimony. So now that the court has found that Ms. Nowlin is qualified as an expert, the court must determine whether her testimony will assist the tier of fact in understanding the evidence. He goes on to talk if an expert's testimony is competent and relevant and may be admissible, the weight given to the testimony is left to the tier of fact. So they're saying the defendant argues Ms. Nowlin's rebuttal opinion that the DNA detected on Q1.1 or under Maddie's fingernails is likely the result of a direct transfer is speculative because it offers possibilities that are not based on substantive scientific principles. The state responds that Ms. Nowlin's rebuttal disclosure sufficiently explains the scientific principles underpinning her opinion and the reasons for her opinion. In addition, the fact that Ms. Nowlin cannot testify conclusively as to when and how the DNA arrived on the knife sheath does not, according to the state, render her opinion speculative or otherwise unhelpful to the jury. The court finds Ms. Nowlin has identified an adequate scientific basis for her opinion. So Ms. Nowlin's opinion does more than suggest possibilities. She states that while it is possible the DNA on the knife sheath was from the secondary transfer, it is more likely that the result of direct transfer, given that the DNA was a single source profile, and that 2, there was a 0.168 mg of DNA detected on the knife sheath. As the state points out, the expert may testify to the likely opinion, particularly where the expert acknowledges the limitation of such opinion. So basically saying her opinions will not be excluded. Now the next one is misleading DNA labels are to be avoided. The defendant next argues that the term touch or contact DNA should be excluded under IRE 403 because it could mislead the jury into inferring that the depositor of the DNA actually touched the object on which it was found. The state only addresses the term touch DNA and argues it should not be allowed that it should be allowed because it is a common term within the field. He says, given the ubiquitous of the term touch DNA, it is not only the forensic DNA field, but in the legal and scientific field as well, the court is unwilling to prohibit the term. That said, the court asks that counsel avoid the use of terms as much as possible to avoid any potential confusion that can be bypassed. To this end, the parties are instructed to submit a mutually agreeable instruction to provide the jury in case of the terms are inadvertently used. If the witness uses the term, opposing counsel can examine the witness about the broader meaning of the term within the forensic community, and the instruction might be given at that time. Regarding Ms. Nowlin's rebuttal, opinions are proper. Defendant's final argument is that Ms. Nowlin's anticipated rebuttal testimony is improper because it does not respond to any opinion by defendant's own expert regarding the DNA transfer. The court does not agree. So Ms. Riley Nowlin is granted and in part denied in part as well. So that's that motion in limine 4 regarding Riley Nowlin and her being able to use the words touch and contact DNA and to testify in general. If you like this, make sure you give this like and a follow because I will be bringing you the next ones.